Hi, and welcome to the Kingsley Napley session at Kidz to Adults 2021. My name is Simon Hardy, and I'm a partner in charge of the Court of Protection team at Kingsley Napley Solicitors. It's a real shame that we're not able to meet you in person this year, as that's usually one of the best things about attending Kidz. I still remember going to the last event in Coventry in March of last year, just as lockdown was starting. Even though it was a little strange, with less people there than normal, it was still great to see everybody, and hopefully we'll do the same again next year. You're about to see some videos and recordings, and what I would say is please do ask questions as we go through the session. The team will be available and be happy to answer any questions that you do have. As I said, I'm the head of the Court of Protection team at Kingsley Napley. We are a team dedicated to helping individuals who have issues with their mental capacity and need to involve the Court of Protection. So what we generally do is act as a deputy for individuals that lack capacity, and that might be because of catastrophic injuries at birth, or it might be due to old age or mental health issues. And we'll talk more about that as the session goes on. You'll also be hearing from different members of the team who will hopefully be answering a lot of the questions that parents often ask. You'll also hear more about the role of a deputy, and in particular about something called a statutory will, but we'll explain more later. At the end, we'll also be showing a video made with one of our clients who shares his experience about how he has managed to adapt his home and manage his financial affairs whilst coping with cerebral palsy due to negligence suffered when he was born. I act as his deputy, and we've worked together over many years, and his video is a real success story of how you can cope with these sorts of problems.
Hi, my name is Sophie Cook. I'm an associate in the team. I assist with the day-to-day management of our clients' affairs. Most of my work is with clients who have suffered severe brain injuries, particularly cerebral palsy.
Hello, I'm Anita Gill, a partner in Kingsley Napley. I'm a panel deputy often appointed by the Court of Protection to manage the affairs of those who are no longer able to, or if there has been an issue with an existing deputy or attorney.
Hi, I'm Lauren Nair. I'm associate at Kingsley Napley. I'm responsible for the management of clients' financial affairs, specialising in clients with dementia and those who suffer from serious brain injuries and long-term impairments.
I am Samina Munir, and I am an associate in the team. I assist the deputies with applications relating to property and affairs in the Court of Protection.
Hi, I'm Gemma Garside. I'm a senior associate in the Court of Protection team. I assist with complex applications to the court, assisting deputies with their roles, as well as advising on health and welfare matters for both children and adults. My colleague Simon is now going to explain more about the Court of Protection, mental capacity, and the role of a deputy in assisting those who are found to lack capacity to manage their affairs.
The Court of Protection is there to make decisions on behalf of any individual in respect of either their financial affairs or welfare matters when they can't take those decisions themselves. Basically what we're saying is that they lack capacity, and that lack of capacity can be the result of an accident, medical negligence, or even just plain old age and the onset of dementia and similar illnesses like that. What the court does is appoint an individual known as a deputy by way of a court order to take decisions on that person's behalf. Now typically these people are quite vulnerable, and hence you have the name Court of Protection. Its role is to protect. It's not a very well-known court, but is becoming more and more well-known. There's been a lot of publicity recently, and with the ageing population it's likely that more and more of us will come across it during our lifetime. I typically act either as a professional deputy on behalf of somebody that's lost capacity, or I advise a family member or friend who are going to act as a lay deputy.
So do most people have a professional deputy?
Not necessarily. It largely depends on the circumstances of the individual involved. Most of my clients have suffered catastrophic injuries, either as a result of an accident or medical negligence, and have been awarded very large sums of compensation as a result. Their affairs are therefore necessarily complex, and it is usually appropriate in those circumstances for a professional to be appointed. The role of deputy is quite onerous, and so it is a difficult decision to take for a family member or friend to take on that responsibility, but if somebody's affairs are not too complicated, then it's not uncommon for them to act.
So what's your approach as a professional deputy?
As a deputy, I'm appointed by a court order, and that gives me a clear set of rules and powers that I can work to. It's not just a legal role, there's a lot more involved being a deputy, and you have a very personal relationship with your client. So if I'm to do my job well, I need to know my client and also know their family and friends. If I make a decision on an individual's behalf, then I have to be certain that what I'm doing is in their best interests. In doing so, I obviously therefore need to talk to my client and talk to their family. I also have to bear in mind that I'm not dealing with my own money, and therefore I can't impose my views or my values. And when deciding best interests, I have to take into account the individual concerned and what their wishes might be, and what they might have been before they had their accident or injury.
Will I be relinquishing all areas of responsibility of my financial affairs if I appoint a deputy?
Not necessarily. The Mental Capacity Act, which is the main piece of law that governs the work of the Court of Protection, is an empowering piece of legislation. One of its primary aims is to ensure that people are able to make their own decisions whenever possible, and even if a deputy is appointed, they're encouraged to assist their client to make as many decisions as they can. It's not my job as a deputy to make decisions on what food you're going to have that evening, what clothes you buy, or where you go on holiday. Obviously, my job is to make sure the money is available to do that, but at the end of the day, we all make our own decisions about routine matters without the involvement of the professional.
Do I have a choice as to whether I involve the Court of Protection?
The Court of Protection only becomes involved when there is clear evidence that somebody lacks capacity to make their own decisions. That's usually by way of a medical report from a doctor. Unfortunately, if the evidence is clear, then we have no option other than to go to the Court of Protection. However, this doesn't stop the rest of us from planning for our future, and we can all make something known as a lasting power of attorney. This is very similar, but allows us to choose who we would want to manage our financial affairs or our welfare matters if at some point in the future we subsequently lost capacity.
Now that we've heard from Simon about what a deputy does, we are now going to hear about questions we are regularly asked by parents. One of the key questions is, how do I change my child's deputy? If your child lacks capacity and needs the support of a deputy to manage their financial affairs, then it is essential that you are working with the right person, as they have such an important role to play. You should consider whether they take into account your wishes, or do they seek to impose their own values and judgments on how your child's affairs are managed. Many people don't realise that the situation does not have to be like that, and they can change their child's deputy if they wish. A deputy is appointed by a court order, and only the court can decide who that should be. The process of appointing a deputy can take several months, but if the relationship isn't working, you are not obliged to stay with the same deputy. As with any relationship, there can be a clash of personalities, and sometimes change is necessary.
We are often asked by families about what will happen when a young person turns 18 and the parents no longer hold parental responsibility to make important health and welfare decisions on their behalf. Any important decisions will be made through a best interest process, whereby the authority with responsibility for the young person will ultimately make the decision. In cases where a child lacks capacity to make decisions about their health and welfare, their parents, or indeed any concerned person over the age of 18, may apply to the Court of Protection to make decisions on their behalf. However, the court will need to be satisfied that such authority is necessary and proportionate, and that the kind of decisions that need to be made are frequent and complex.
If you have a professional deputy, they will charge a fee for their services, and this will be paid from your money. However, your deputy cannot just pay themselves as much as they like. Every year, the deputy must send their bill to the Senior Courts Cost Office, who will decide how much your deputy is allowed to charge.
Your deputy needs to report to the Office of the Public Guardian every year about what you have spent your money on. The Office of the Public Guardian, or OPG, will look at this report carefully and can ask questions or request further information. If you are concerned about how your deputy or your attorney under a lasting power of attorney is behaving, you can ask the OPG to investigate. If there are serious concerns, then the OPG can make an application to the Court of Protection for your deputy to be removed.
The appointment of a deputy isn't a permanent thing. and you only need a deputy if you actually lack mental capacity. It sometimes happens that your condition can improve and you subsequently regain capacity. And if that does happen, then the Court of Protection will make an order discharging your deputy, restoring you to the management of your affairs so that you can then make all the decisions for yourself. Also, if you are not getting on with your deputy, and I'm afraid that does sometimes happen, then you can ask the court to remove them and appoint someone new. If the court agrees that this will be in your best interest, then a new deputy will be appointed.
The Office of the Public Guardian has a list of experienced deputies known as panel deputies. If you need a deputy and there are no family members willing or able to act, then the court, as a last resort, may appoint a panel deputy to act for you. An important issue that parents may face when their child is transitioning to 18 is ensuring their affairs are in order through a will. If a young person lacks testamentary capacity to make a will, then an application has to be made in the Court of Protection for what is known as a statutory will. Samina is going to explain to you in detail now this short piece. You will then be able to see a video about how our firm has assisted one of our clients who suffered a brain injury at birth.
A statutory will is a special will made by the Court of Protection for people who don't have capacity or the understanding to make one for themselves. As like with everyone else, you need to be at least 18 years of age before you can make one. You might need a statutory will in several circumstances. Firstly, if you don't already have a will, your estate would pass under the intestacy rules and you might need one to put your affairs in order. Secondly, if someone already has an existing will, this might need to be updated to reflect the current circumstances. And thirdly, if there are any troublesome or difficult family dynamics, a statutory will might prevent a potential dispute post-death. Before you can get a statutory will, the first thing you need to do is obtain medical evidence to show that the person cannot make a will in the usual way. Once that's been obtained, you would then make an application to the Court of Protection, including a proposed statutory will and an explanation as to why it is in that person's best interests for that to be approved. The application can be made by an attorney, deputy or beneficiary under the will or under intestacy rules, and it usually takes about 6 months, but it can take longer if disputed. However, that being said, the court can consider applications on an urgent basis if there is a very short life expectancy, but you would need to clearly demonstrate this in the application. In the statutory will, you can ask for all the regular provisions, so for example, the appointment of executors, funeral wishes, leaving gifts to friends and family and possibly to charities, and it would also discuss how you would wish the estate to be left amongst friends and family. The court, however, would need to be satisfied that the will would be in that person's best interests. This can be sometimes tricky to show, but one would expect someone to consult with friends and family and also consider the person's past wishes and feelings. And if the testator can voice an opinion about how they would want their estate to be left, this is something that the court would want to hear about. A statutory will has exactly the same effect as a will drafted by someone else. The only difference is the way in which it is made.
Sophia was Claire's second child, born in the early 1980s. Claire had a completely normal pregnancy and a normal first stage of labour, the contraction stage as she was dilating, arduous but normal. The problems really started as she entered the second stage of labour when she was fully dilated.
When I was born, I have brain damage and the cord was around my neck too many times.
My husband thought he was dead, and I think it took an extra few minutes for the paediatrician to arrive to resuscitate him. He wasn't there at the time. So he had an extra few minutes after he was born, again without oxygen. And it took them a long time to resuscitate him.
There was nobody with the skills to intubate him at the time when he needed intubation and to resuscitate him, much as staff at the time tried. They didn't have the skills to do it until the paediatrician arrived, and then he was successfully resuscitated. But by then, the damage had been done.
We never really grasped the idea that anything was wrong until much later, when he really was not developing as he should. And then it became obvious.
He was subsequently diagnosed with cerebral palsy of the dyskinetic type, which means it affects his movement, his limbs and speech in particular. Somewhat unusually in this case, Claire focused for many, many years on dealing with Sofiane's needs rather than thinking about fault. You know, why was Sofiane like this? What could have been done differently? That wasn't something that she focused on until Sofiane was in his late teens, when a chance conversation with a lawyer from Kingsley Napley in, I believe, a social event, meant that made her question, what was the standard of care I received? Should things have happened differently?
She said that she worked for a firm of solicitors who specialised in medical negligence, and would we be happy for her to look into it for us? Would we like her to look into it for us?
What was quite clear from the outset of this case was that Sofiane had the type of cerebral palsy which was caused by a damaging period of hypoxia. What we did was to look at whether any reasonably responsible doctor would have allowed that second stage of labour to have gone on for so long, and should something have been done to expedite delivery. We looked carefully at the CTG trace, which gives you information about what's happening with the baby's heartbeat. The CTG trace only actually ran for an hour. The last half hour, there was no record at all of the baby's heartbeat. Within that, we saw 2 areas of serious abnormality. There was some recovery in the middle. And we had to look very carefully at whether those abnormalities were sufficient, at least serious, to mean that delivery should have been expedited. And our argument was that yes, there should have been an episiotomy and an instrumental delivery to avoid what became subsequently the damaging period of hypoxia.
Pursuing a claim like this has quite an impact on the family. There's quite a lot to do, quite a lot of paperwork to get through. There's meetings to attend, and there's a lot of things that you have to think back on and recall and write down, and that can be quite a difficult thing to do. It's not easy to sort of recall and remember things that you've almost pushed to the back of your mind.
She had to read all the evidence, come to meetings, hear what happened again and again, and my job, as I saw it, was to make her job as easy as possible. She
would guide us through every part of the claim as it went on. If there was ever anything I needed to ask her, I felt very comfortable to ask her, and she would explain it in a way that I could understand.
What the purpose of what we are doing is to put the claimant back into the position he or she would have been in but for the negligence. And what that means is that we are looking very carefully in minute detail at the financial implications of the care packages, of physio, of OT. Often this will require some involvement of the litigation friend, and so we work together as a team so that the litigation friend, in this case Claire, feels comfortable with the experts, with the appointments with the experts, with the reports that come out, so that her involvement is there but supported.
Going through the claim was quite an education for me. There were meetings to attend with all the various experts and things, and it's quite evident that they are all there for you. They're there for the benefit of your child and your family.
of the difficulties that you find when you have claimants who have quite a lot of ability as well as quite a lot of disability is actually when you're doing the crystal ball gazing is what is the future going to hold for this person. It's actually not so clear cut as the person who obviously needs 2 nurses 24 hours a day. And with Sofiane, what we had to do was to work very carefully with the family to take Sofiane's own individuality into account.
As a court protection lawyer, my first involvement is generally when we've been presented with medical evidence that says our client lacks capacity to manage their property and affairs. At that point, we know we need to involve the court of protection, and usually we apply to them for the appointment of what's called a deputy. That's the term the court uses for the individual who will manage that person's finances or, in some circumstances, welfare matters on their behalf.
In this firm, we are fortunate to have a whole team of people that deal with deputyship work. And that means that there's continuity from the litigation forwards.
We often become involved towards the end of a claim or even only after it's been finished. In Sofiane's case, that's what actually happened. There was no money available before that point. Now, up to that point, the family and the client have been through an awful lot of stress, and then their circumstances have changed dramatically. It can be a crucial time for them because suddenly they don't have the anchor of the claim to look back to, and they have to think about the future. They have to think about what to do with the money, and that's where we step in and guide them forward. We're responsible for all aspects of his financial affairs, and that's covered matters such as purchasing his property and adapting it, through to investing his funds, through to more mundane matters such as providing him with his weekly spending money, and of course ensuring he has an appropriate care regime so that he can live the life that he wants to live.
He'll receive an allowance once a month from his deputy, and he more or less manages his own money himself. It's one of his steps towards independence. Once the claim was settled, the next step after that was to find a home for Sofiane to live. He needed a lot of space. This one was great because we could adapt it and make it more suitable for him.
This is where it stopped before, wasn't it? And then we built this, didn't we? We got an architect and had it all designed. Yeah.
I like it. I really like it.
Living here, he's in charge of his own life. He's never had this much control on of his own life.
It took us quite a long time to get the right care package in place because we wanted to ensure that it was the right people working with Sofiane. The kind of people that would allow him to live the life that he wants to lead, which is quite a busy and active life, essentially just the same as you and I.
At most days, I go to drama, cycling, go-karting.
He goes go-karting now. And his carer goes with him and they race each other. They have a whale of a time. He's been on an adventure holiday. He does everything.
Thank you for listening and for watching our videos, and I hope you found it useful. We obviously hope to see you again in person at the next Kidz to Adults. As you can tell, this is not my natural environment, and I much prefer seeing you face to face so that we can talk things through properly. Nonetheless, please feel free to get in touch with us for no obligation discussion about your child's circumstances or for any other issues that you want to raise. We're always happy to help.